We all kind of think of family law as this single, clear set of rules, right? For all the big moments in life. But what if it's not? What happens when a country doesn't just have one rule book for marriage, but three?
Seriously, just imagine trying to play a game with 3 different referees on the field, and each one is calling fouls based on completely different rules. It would be total chaos. Well, for countless families in Uganda, that's not just some thought experiment. It's their reality. And that's the puzzle we're going to unpack today.
So to really get this puzzle, we have to start at the beginning. Let's look at that classic, almost universal idea of marriage that Uganda, like a lot of other Commonwealth nations, got from English law.
This definition, it comes from this landmark English case from way back in 1866. It laid out the blueprint. Marriage is a voluntary union for life of one man and one woman to the exclusion of all others. You know, the whole package. This became the bedrock for civil marriages and church marriages in Uganda. One man, one woman, for life. Simple enough, right?
Well, not so fast. Because right away, that one simple idea smacks right into a much more complex reality. While civil law is all about monogamy, there are 2 other legally recognized systems in Uganda, customary law and Islamic law, and both of them allow for polygamy. So right from the get-go, you've got 2 completely contradictory ideas of what a legal marriage is, both existing at the same time under the same flag.
And believe me, this isn't just some academic debate. This clash of rule books creates very real and often heartbreaking legal puzzles for everyday people. This is really the heart of the issue. Experts call Uganda's family law a legal patchwork. Think of a quilt stitched together from 3 totally different fabrics, with patterns that just don't match up. The problem is, if you're an ordinary person, at the most critical moments of your life, like a divorce or the death of your spouse, it's anybody's guess which piece of that quilt, which set of rules is actually going to apply to you.
Let's look at a real case to see how messy this gets. A man, Senefuka, and a woman, Goretti, they get married in a Christian church. That's a monogamous union, one man, one woman. But years later, Senefuka converts to Islam, a faith that allows a man to have up to 4 wives. He then tries to marry a second woman, Fatuma. So, what gives? Is his first marriage still legally binding? Can he just switch rulebooks midstream? Which law is supposed to win here? It's an impossible knot.
Now, if you thought that was complicated, buckle up. Because this puzzle turns into an all-out conflict when you add another layer. Uganda's modern constitution, which brought in a whole new set of values that go head-to-head with the old laws.
Just take a look at divorce. The old law, the Divorce Act from 1904, is just unbelievably one-sided. For a husband to get a divorce, all he had to prove was adultery. That's it. But for a wife? Oh no. She had to prove he committed adultery, plus another major offense like cruelty or desertion. Then, bam. In 1995, the new Constitution comes along and says, loud and clear, that men and women have equal rights in marriage and when it ends. The 2 laws are in a direct stare-down.
And you see the exact same conflict when it comes to inheritance. The old law says that if a man dies without a will, the family home goes to his legal heir, which almost always means his eldest son or closest male relative. And the widow? She doesn't inherit her own home. She just gets a limited right to occupy it. Basically, she can stay, but she's living at the mercy of her in-laws. This can tear families apart, separating mothers from their kids, which completely flies in the face of modern principles that say the child's best interests have to come first.
And if you really want to understand the worldview behind some of these old laws, just listen to this. When one clan leader was asked if a widow had a choice about being inherited by her husband's relative, he said this, "You are asking me whether she has a choice? I have never heard such a question." The very idea that she might have a say in the matter, it wasn't just wrong, it was unthinkable. It wasn't even a question.
So this is way more than just dusty old law books arguing with each other. These legal contradictions have a profound and often devastating human cost. And it's usually the most vulnerable who have to pay it.
Remember those 3 clashing rule books, civil, customary, and religious? This isn't some rare legal oddity. For so many families, this is their life. Their most fundamental rights to their home, their property, their children are all caught in a fog of legal uncertainty.
And let's be clear, in this kind of legal chaos, there's a predictable pattern. It's almost always women and children who pay the highest price. They're the ones left without a home, without any property, and sometimes, tragically, without each other.
The custom of widow inheritance shows just how grim this can get. Let me walk you through it. A husband dies. His relatives often just swoop in and seize the property. Then, the widow is given an impossible choice. If she wants to stay in her home, on her land, she has to agree to be inherited by one of her late husband's male relatives. It's essentially a forced marriage, where she loses all control over her finances, her body, and the rest of her life.
And the children in these situations are direct victims. They're often ripped away from their grieving mothers. Relatives might take custody, claiming it's for the child's care, but often it's really a move to control the property left behind. This is a clear violation of a child's right to be with their parent. And for daughters, the outcome can be even more horrific, as they're sometimes married off quickly, just locking another generation into that same cycle of powerlessness. So you have to be wondering, is anyone trying to fix this broken system? Well, the answer is yes, but the fight for reform has been a marathon, not a sprint.
And it has been a long fight. I mean, the first major call for reform was back in 1965. The 1995 Constitution was a massive step forward, putting equality into the highest law of the land. In 2003, the Constitutional Court even struck down those unequal divorce rules. And yet, the one thing that could actually fix this mess, a modern unified marriage and divorce bill, has been stalled in Parliament since 2009, for over a decade.
And here's the real bottleneck. A court ruling or a constitutional right doesn't automatically erase an old law from the statute books. That's Parliament's job. And until they actually do that job, until they pass a clear, modern law to replace the old, contradictory ones, Uganda is stuck in this legal limbo. The confusion and the injustice just continue. And that leaves us with one last, really big question. And it's not just a question for Uganda. It's for any society. When a nation's own laws are at war with its own constitution, with its most fundamental values, who is responsible for finally stepping in and declaring peace?